All right, I see that we are being live streamed, so I think we're set to go. Good evening, everyone. I'm Judge Dean for this evening. And let's make sure everybody is here. Advocate for the government, is that you, Ms. Branham?
Yes, Your Honor.
Okay, nice to see you. Good evening. And we have the advocate for the defense is it Podolsky, Ms. Podolsky?
Yes, good evening, Your Honor. My name is Rochelle Podolsky, and I'm here on behalf of the defendant, Elizabeth Bartlett.
Okay. And at the moment, I'm just checking to make sure everyone that we need is here. I think we have Ms. Goodman and Mr. Newman. Are you both online and ready to go?
Yep, good to go.
Yes.
Okay. Okay, great. All right, thank you, everyone. So we are on the record now in the case of United States v. Elizabeth Bartlett. Let's make appearances again, even though I know you sort of did already, but for the record, prosecution, please make your appearance.
Yes, good evening, Your Honor. I'm Abby Branham, today here on behalf of the government.
All right, thank you. And defense, please make your appearance.
My name is Rochelle Podolsky, and I'm here on behalf of the defendant, Elizabeth Bartlett.
Okay, great. Nice to see you all. Do the parties have any issues or motions that you've been unable to work out before trial?
None that
Let's start with the government. I'm sorry, go ahead.
Yes, Your Honor. None that we were unable to work out. We just want to state those for the record at this time, if that's all right.
Okay, go ahead.
So first, pursuant to the pretrial order in this case, we have 3 exhibits that have been pre-admitted. They're all forensic reports. Those are exhibits numbered 3, 11, and 14. And then both sides prior to trial have agreed to pre-admit some exhibits, some photographs and documents in this case. Those exhibits are the photographs 1 and 2, 8 and 9, and then exhibit 10. And the documents that we've agreed to pre-admit are numbers 6 and 7. And on behalf of the government, we had one other substantive agreement that we came to.
Okay.
Just the exclusion. There was a past trial in this case regarding the defendant on these facts. We've just agreed to exclude any mention to that past trial or its result for impeachment purposes, just referring to it as prior in-court sworn statements being made.
All right. I am with you so far. Anything else?
We just have a few brief housekeeping matters, if Your Honor would like to address those at this time.
Sure, let's do that.
First, due to our online format, may we constructively assume all objection arguments are heard at sidebar outside the ears of the jury?
Yep, we can do that. That's fine.
Yes, Your Honor. And then the pre-markings on these exhibits that we've talked about, may we refer to those exhibits by their pre-marked designations regardless of the order they come into to the trial today?
Yes, yep, absolutely.
And then in terms of publishing those exhibits for the jury, do we ask permission before ever publishing them each time, or just the first time we go to publish?
Just the first time for each one.
Yes, Your Honor. And with that, the government's ready to proceed.
All right. And Ms. Podolsky, anything from your side?
Yes, Your Honor. The defense has a few additional housekeeping matters to attend to. When objecting, would you prefer that we say objection, objection rule, or objection rule and explanation?
I don't really have a strong preference. Let's make it simple, just objection, and then I'll let you know that I'm ready to hear from you.
Understood. Thank you, Your Honor. And in addition to the pre-admitted evidence as opposing counsel has stated, we also had a motion in limine prepared for today's trial. However, during meet and confer with opposing counsel, we've also stipulated, and that is that we preclude any mention of Elizabeth Bartlett's present marriage to Matt Santos.
Okay, very good.
And with that, the defense is ready to proceed with opening statements.
Okay, very good. All right, let's move ahead with opening statements. Ms. Branham?
Yes, Your Honor. May I reposition myself prior to beginning?
Sure. You may proceed when you're ready.
Yes, Your Honor. The timeline doesn't lie. It's Christmas Day, 1997. The defendant, 28-year-old Elizabeth Bartlett, and her 67-year-old husband are arguing. She's come home late one too many times, and her husband's had enough. He accuses her of having an affair. He says he wants a divorce. And that's a problem. Because the defendant knows that if her marriage ends in a divorce, she walks away with nothing. But what the defendant also knows is if her marriage ends with the death of her husband, she walks away with everything. His entire $72 million estate. You're going to learn today that just a week after this Christmas Day fight, on New Year's Day, 1998, the victim, Martin Bartlett, was shot and killed in his bedroom while he was sleeping. Today, we've charged the defendant with first-degree murder for that death. Now, as the government in this case, I have a job today. My job is to prove beyond a reasonable doubt that it was the defendant that intentionally killed Martin Bartlett on January 1st of 1998. So how am I going to meet that burden to you today? I'm going to meet that burden by showing you the picture the evidence paints in this case, by showing you the timeline. Because the timeline doesn't lie. Members of the jury, we're going to break up the timeline in this case into 3 separate parts, starting with that week leading up to the victim's death, starting with Christmas Day of 97. You're going to hear that an eyewitness observed this fight between the victim and defendant. You're going to hear the victim told the defendant he wanted a divorce and that he was killed just 7 days later. But that's not the only thing you're going to learn about that fight. Because you're also going to learn what was in the defendant's mind while it was happening. Today, you're going to see not one, but 2 separate documents that governed the Bartlett's marriage relationship. First, you're going to see the prenup that the defendant signed just a year prior. The prenup that meant if this marriage ended in divorce, the defendant walked away with nothing. But you're also going to see the victim's will. A will that meant for the defendant, if this marriage ended with the death of her husband, that she'd walk away with a $71 million check she got to cash. The second part of the timeline we're going to talk about is the day of the murder, January 1st, 1998. You're going to learn that an autopsy was performed in this case. An autopsy that places the victim's time of death between midnight and 12:30 a.m. on January 1st. But you're also going to learn that law enforcement in this case wasn't called by the defendant until 2 hours later at 2:30 in the morning. Today, you're going to hear testimony from the lead investigator in this case, Detective C.J. Conanan. He's going to take the witness stand and tell you that he asked the defendant about that missing 2-hour gap. That he asked the defendant, what happened to your husband? You're going to learn about what her response was on scene on January 1st. That she had an elaborate story about a masked burglar breaking into her home to rob her and her husband, killing him, and leaving the scene. But you're also going to hear from Detective Conanan about the physical evidence that was recovered in this case. You're going to learn about a pair of women's size small gloves found 100 yards from the defendant's home, covered in gunshot residue and the victim's blood. You're going to learn that all the stolen jewelry in this case was found in a neighbor's trash can in the same neighborhood 2 doors down. But members of the jury, that's not the only physical evidence you're going to see today, which brings us to the third part of our timeline. You might be asking yourselves, this murder took place back in 98. What are we doing in court today in the year 2024 talking about it? Well, we're here today because of the evidence the FBI recovered 25 years after this crime occurred. A single fingerprint from the bullet shell casing found under the victim's nightstand. You're going to learn that back in 98, there were no usable prints that the FBI could find. But with advanced forensics today, you're going to learn that the FBI found not only a usable print, but a print that matched the defendant in this case. Members of the jury, throughout the course of this trial, you're going to hear multiple competing stories about what happened on January 1st of 1998. When you're hearing these stories, I only ask that you weigh them up against the evidence in this case, that you weigh them up against the timeline. Because unlike people, timelines don't forget. Timelines don't lie. That's why at the end of this trial, I'll ask that you will do the only thing the law and the evidence will demand, and find the defendant guilty of first-degree murder. Thank you.
Thank you, Ms. Branham. Ms. Podolsky, are you ready to go?
Yes, Your Honor.
You may proceed.
Elizabeth Bartlett didn't do it. The government cannot prove she's guilty because of their immediate assumptions, which led to insufficient proof and an inaccurate story. Good evening, members of the jury. My name is Rochelle Podolsky, and I represent the defendant, Elizabeth Bartlett. As the defense, we bear no burden in today's case. The government alone bears the burden to prove that Elizabeth Bartlett intentionally killed Martin Bartlett beyond a reasonable doubt. That means Elizabeth Bartlett remains innocent until you are left firmly convinced of her guilt. At the end of this trial, the government will fail to meet their burden because of their immediate assumptions, insufficient proof, and inaccurate story. I want to start by introducing you to the woman that the government will solely refer to as the defendant. Elizabeth Bartlett sits here today as the 54-year-old widow who lost her husband to a violent intruder. Let's take a step back to New Year's Eve of 1997 and discuss what actually happened. That evening, Mrs. Bartlett laid right next to her husband as a 6'3" male in a ski mask and gloves walked right up to Mr. Bartlett, fired one shot, and killed him. Now Mrs. Bartlett sits here wrongly accused of murder. Let's start with the government's immediate assumptions. The evidence will show that Detective Conanan made up his mind before he even began to investigate. From the moment he arrived at the scene 26 years ago, the detective honed in on Mrs. Bartlett and Mrs. Bartlett alone. You're going to learn that Detective Conanan noticed signs of an intruder, but ignored them. The detective will tell you himself. He noticed a broken window, broken glass, a wide open back patio door, stolen watches, stolen cash, a missing gun. But these things didn't play a role in his investigation because he immediately assumed Mrs. Bartlett was to blame. These assumptions led the government to discover a partial print on a single shell casing. Which brings me to my second point. The government's insufficient proof. In order to explain their newly discovered fingerprint match, the government will give you an examiner's report. Not an expert, not a witness, a report. But we will have Sam McGary take the stand, who is an expert in fingerprinting and forensic science. Mr. McGary will explain to you how out of all of the loops, whorls, and arches that make up a print, there are only 8 in common between the partial print on the single shell casing and Mrs. Bartlett's finger. The government will try and tell you that they found a sufficient match. But Mr. McGary will tell you that they didn't. The evidence will show that it's filled with reasonable doubt. The evidence will also show that 26 years later, we don't have a murder weapon. No matter what the government says or does today, they will not be able to stand in front of you and tell you that we have a gun. Because 26 years later, all they have is that shell casing. This brings me to my third point. The government's inaccurate story. The government has already spent a lot of their time telling you a story about Mrs. Bartlett and a story about how the timeline doesn't lie. They want you to focus on this story about the money Mrs. Bartlett stood to gain for killing her husband. But members of the jury, you're going to learn that in order for this story to be accurate, to make sense, Mrs. Bartlett must have known about the $71.4 million she would inherit if her husband died. None of the evidence today will prove this. You won't even hear that Mrs. Bartlett knew about the contents of Mr. Bartlett's will. The government's case is built on their immediate assumptions, which led to insufficient proof and an inaccurate story. As you remember that, you will see that the government has failed to meet their burden beyond a reasonable doubt. At the end of this trial, I will come before you and ask you to find the only verdict consistent with the facts, the law, and your own common sense. Find the defendant not guilty. Thank you.
All right, thank you, Ms. Podolsky. Is the government prepared to call its first witness?
Yes, Your Honor. At this time, the government calls Detective C.J. Conanan to the stand.
All right. Very good. You may proceed.
Good afternoon. Please introduce yourself to us.
Good afternoon. My name is CJ Concanon.
What line of work are you in?
I am a detective for the Lower Merion Police Department. I've been a detective for about 30 years.
I want to talk about your investigation in this case. What kind of training and experience do you have as a law enforcement officer?
I have training and experience in ballistics, crime scene investigation. I also graduated with honors from the State Police Academy.
Detective, were you involved in an investigation involving the death of somebody named Martin Bartlett?
Yes, ma'am. I was the responding officer on the scene about 20 minutes after we received the 911 call.
And when did the victim die in that case? What date?
On January 1st, 1998, approximately 12:15 a.m.
Did you make an arrest in that case?
Yes, ma'am, we did. We arrested his wife, Mrs. Elizabeth Bartlett.
Do you see her in the courtroom today?
Yes, ma'am. She is seated at a defense table wearing a blue suit with a pink blouse.
Let the record reflect the witness has identified the defendant in this case. Would you recognize a photo of the defendant from 1998 if I showed it to you in court today?
Yes, ma'am, I would.
You're under permission to display Exhibit 2, which has been pre-admitted in today's case.
You may.
Detective, who are we looking at here?
This is Mrs. Elizabeth Bartlett around the time that she married Mr. Bartlett in 97.
And would you recognize a photo of the victim in this case, Mr. Bartlett, if I showed that to you today?
Yes, ma'am.
You're under permission to display Exhibit 1, which has been pre-admitted.
You may.
Detective, who is this?
This is Mr. Martin Bartlett, the deceased victim in this case.
All right, Detective, I want to start at the very beginning. What was the first thing you did in your investigation in this case?
I first arrived at the Bartlett's home at about 2:50 a.m. I was greeted at the door by Mrs. Bartlett. I then went upstairs and saw the room where the defendant where Mr. Bartlett was lying dead.
When you were greeted by the defendant at the door of her home, what, if anything, did she say?
She told me that Mr. Bartlett had been shot, that there had been a break-in.
Detective, what was the defendant's demeanor when she told you her husband had been shot and killed?
The defendant was very calm, conversational. Her voice was steady.
Yes, let's hear your objection.
Your Honor, this is improper opinion. This witness is not competent to testify to the witness's emotional state.
What was it specifically that you believe was related to the emotional state?
The fact that she was calm at the time, I have no problem with this detective testifying as to what he observed, but to say that she was calm, that is stepping the line of his opinion.
All right, response.
Your Honor, I believe Detective Conanan was speaking to her observations on scene. So she described conversational, calm, her observation of the defendant as she appeared on scene that night. I believe she was just testifying to her observations, and certainly that's all my question called for.
All right, any further argument, Ms. Podolsky?
No, Your Honor, I just stand by my initial argument.
All right, thank you. Objection overruled.
Yes, Your Honor.
Please continue.
Detective, were you able to finish your answer? What was the defendant's demeanor when you greeted her on scene?
She appeared calm, conversational. Her voice was steady. She didn't seem disturbed at all. She was almost relaxed.
Detective, I want to start by talking about the account the defendant gave you about January 1st, and I want to compare that to the physical evidence you found in this case. Is that all right?
Yes, ma'am.
To start, when did the defendant say the victim had been shot and killed? Did she give you a time?
Around 2 a.m.
Are you aware if an autopsy was performed in this case?
Yes, ma'am. I reviewed the autopsy report in preparing for today.
And what time did that autopsy place the victim's time of death?
I was present at the autopsy, and the medical examiner placed the time of death at between midnight and 12:30 a.m.
All right, Detective. Well, you said the defendant told you a burglar had broken in and killed her husband. Did she say anything about where this person had been standing?
Yes, ma'am. She informed me that the assailant, the intruder, had been standing at the foot of the bed.
And what did she say about the victim's position at the time he was shot?
She stated that Mr. Bartlett was sat up in bed.
What did the autopsy have to say about the position of the shooter that night?
The autopsy stated that the shooter was standing right next to Mr. Bartlett. The muzzle of the gun was pressed against his forehead.
And what did the autopsy have to say about the victim's position?
The autopsy stated that Mr. Bartlett was lying flat on his back, resting his head on the pillow.
Detective, what did the defendant tell you about where she was when her husband was shot and killed?
The defendant stated that she was lying in bed next to her husband at the time that he was shot and killed.
Well, Detective, when you arrived on scene, were the defendant's clothes bloody?
No, ma'am, there was no blood on the defendant's clothes.
Did you test those clothes for gunshot residue?
Yes, ma'am, we did.
And how did that test come back?
There was no gunshot residue found on the defendant's clothes.
You said the defendant told you this had been a burglary. Was anything taken from the home that night?
According to the defendant, I didn't take an inventory before I arrived at the scene. There were, according to the defendant, valuables missing, jewelry, watches of that sort.
And that jewelry you mentioned, was it recovered throughout the course of your investigation?
We recovered some jewelry during the course of our investigation, 2 doors down, about $50,000 worth of Mrs. Bartlett's jewelry.
All right, Detective, we'll break that down. Would you recognize a photo of that jewelry in court today?
Yes, ma'am.
Your Honor, permission to display Exhibit 9. That's pre-admitted.
You may.
All right, Detective, is this the jewelry we've been talking about?
Yes, ma'am.
And you mentioned the value of that jewelry. Just to be clear, how much did the defendant tell you this jewelry was worth?
The defendant informed me that the jewelry was worth about $50,000.
And to be absolutely clear, where did you find this jewelry throughout the course of your investigation?
I discovered this jewelry 2 doors down from the Bartlett's home in their neighbor's trash can.
Was that significant to you, the fact that this jewelry was recovered in a trash can just 2 doors down?
Yes, ma'am. In all of my years of investigations and experience, I've never seen another case in which a burglar would enter a home, commit armed robbery, and then throw $50,000 worth of jewelry away. So it was quite odd to me.
All right, Detective, I want to move on now and talk about what the defendant told you about the physicality of the person that night. Did she describe this alleged burglar, the physicality of that person?
Yes, ma'am, she did. She described the intruder as 6'3" male, wearing all black, gloves, ski mask, the whole shebang.
And at any point throughout the course of your investigation, did you find evidence about the physicality of that shooter?
No, ma'am. The only evidence that we found was a pair of size small women's gloves, which appeared connected because they had blood on them, but nothing that was consistent with a 6'3" male.
All right, would you recognize a photo of those gloves in court today?
Yes, ma'am.
Your Honor, permission to display Exhibit 8, which has been pre-admitted.
You may.
All right, Detective, I want to talk some more about these gloves. Where exactly did you find them in this case?
We found them 100 yards from the defendant's home in Oval Park in some bushes.
Did you test these gloves? You mentioned there were blood on them. Did you test that blood?
Yes, ma'am. The forensics team tested the blood found on the gloves for DNA. We found that Mr. Bartlett's DNA was in the blood.
What about for gunshot residue? Did you test these gloves for GSR in this case?
Yes, ma'am. We found gunshot residue on these gloves.
And did the defendant make any statements to you about these gloves?
Yes, ma'am. She stated that she had not previously seen the gloves before.
Did she say anything about their size?
She did. She said that they were her size. The gloves were women's size small, and the defendant stated that she was a women's size small gloves.
All right, Detective, I want to move on now and talk about motive. Did you find that the defendant in this case had a motive to kill her husband?
Yes, ma'am. We found 2 pieces of evidence which we used to establish the motive for Mrs. Bartlett, the defendant in this case. We found a prenup and a will.
Would you recognize those documents in court today?
Yes, ma'am.
Your Honor, permission to display Exhibits 6 and 7.
You may.
Detective, I want to start with this document here on the left. Do you recognize that document?
Yes, ma'am, I do. It's the prenup of Mr. and Mrs. Bartlett, if I'm correct.
And did the defendant make any statements about being aware of this document?
Yes, ma'am. She discussed that they had a conversation about possibly having a divorce in the days leading up to Mr. Bartlett's death. So she did discuss the prenup at the time I interviewed her.
And we'll get back to that conversation, Detective, but just for this document, did she mention to you that she was aware of its existence, believed it to be enforceable?
Yes, ma'am.
And what did this prenup mean if the victim and defendant did get a divorce?
It meant that Mrs. Bartlett would receive none of Mr. Bartlett's assets, so they would return to their previous state prior to their marriage. Mr. Bartlett would retain all of his assets. She would get nothing.
All right, I'd like to turn your attention to the document on the right, the victim's will in this case. What did this will mean would happen in the event of the victim's death?
If Mr. Bartlett were to die, Mrs. Bartlett would inherit his entire estate.
Did you find out how much that estate was worth?
Yes, ma'am. We totaled his assets, liabilities, and his net worth was approximately $71.4 million.
Detective, I want to draw your attention to the second paragraph of the victim's will. Does it name the defendant as a beneficiary of the will or something else?
She was appointed as the executor of Mr. Bartlett's will.
And I just for a moment want to talk about the timeline of these documents. When was this prenup? Can you tell from the prenup when it was signed and created?
Yes, ma'am. The prenup was signed on the 3rd of July, 1996, and they were married on the 4th of July, 1996. What about the will? When was that will created, if you can tell?
The will was created the day after Mr. and Mrs. Bartlett were married, July 5th, 1996. Thank you, Detective. I want to fast forward now to 25 years after this murder. Were you able to uncover any evidence 25 years after January 1st of 98?
Yes, ma'am. We tested the shell casing again in 2022, the FBI's Forensics Science Unit, their specialist, Dr. Emily Hayes, tested the shell casing for fingerprints using a method called electrostatic fingerprinting.
When you say shell casing, detective, where was it located on scene? Where'd you recover it?
I discovered the shell casing underneath Mr. Bartlett's nightstand, so right next to him in bed.
And you mentioned electrostatic fingerprinting. Can you tell us a bit about that method and how it was performed in this case?
Yes, ma'am. Electrostatic fingerprinting is just based on my knowledge, having reviewed Dr. Hayes's report. It's a new method of fingerprinting in which a polymer powder is applied to a piece of evidence. An electric current is then run through that piece of evidence in order to allow investigators, forensic experts to lift a fingerprint.
And do you know if that method's reliable?
Yes, ma'am. It's been used several times in cases throughout the United States, and it is a peer-reviewed method of fingerprinting.
So you mentioned that the FBI used that method in this case and found a usable print. Do you know if they were able to match it to anybody in this case?
Yes, ma'am. Dr. Emily Hayes confirmed that it was a 20-point match with Mrs. Bartlett's right index finger.
Would you recognize that shell casing in court today if I showed it to you?
Yes, ma'am.
Your Honor, permission to display Exhibit 10, which has been
You-
pre-admitted.
You may.
Not sure if I've got the right page up here. Are you seeing the shell casing, detective?
Yes, ma'am.
Okay, I think I'm seeing something different, but that's all right. So this shell casing that you recovered on scene, do you know what type of bullet it came from?
It appeared to come from a 22 caliber Remington bullet.
And was that important for your investigation in this case?
Yes, ma'am. It was consistent with many other findings that we came to during the course of our investigation.
Maybe I can rephrase it. Did you find any of those types of bullets in the victim's home that night?
Yes, ma'am. We found a box of 22 caliber Remington bullets in the defendant's closet. We also found out that he was the owner of a registered 22 caliber firearm.
That box of bullets that you found, how many bullets were in that box?
There were 49 bullets in the box of 50, so only one bullet was missing.
You mentioned that the victim had a gun registered in his name. Were you able to recover that gun in the victim's bedroom?
No, ma'am. We were never able to find Mr. Bartlett's registered gun.
You didn't find it in his home at all?
No, ma'am.
Detective, I just want to talk to you now. We spoke before about the documents that govern the Bartlett's relationship. We mentioned how the prenup governed the divorce. Did you find evidence that the Bartletts had ever discussed divorce?
Yes, ma'am. The defendant informed me that they had argued about the possibility of getting divorced just a few days prior to Mr. Bartlett's death.
And how many days prior to the death did they talk about divorce?
7 days.
Thank you, Detective. I have no further questions at this time.
All right, cross-examination.
Yes, Your Honor. Deputy Commissioner Conanan, I want to start by discussing what you noticed when you first arrived at the homicide scene on January 1st, 1998. Before you got to the Bartlett's home, you had no personal direct knowledge of what happened that evening, correct?
No, ma'am. Just received a phone call.
And when you got there, you saw the Bartlett's 8,000 square foot mansion.
Yes, ma'am.
It was in a gated community.
Yes, ma'am.
When you walked up, Mrs. Bartlett met you at the door, right?
That's correct, ma'am.
Your Honor, I'm publishing what's already been pre-admitted as Exhibit 2. This is a photo of Mrs. Bartlett in 1998.
That's correct, ma'am.
She was 28 years old at the time.
Yes, ma'am.
I'm now publishing what's already been pre-admitted as Exhibit 1. This is a photo of Mr. Bartlett in 1998.
Yes, ma'am.
Mr. Bartlett was 67 years old at the time.
Yes, ma'am.
Now, I want to briefly discuss something you testified about on direct examination. You testified that, in your opinion, you thought Mrs. Bartlett seemed calm and relaxed, right?
Yes, ma'am, at the time that I arrived.
You're not a psychiatrist, correct?
I don't believe no, I'm not.
You're not a mind reader?
No, ma'am.
Let's now talk about what you noticed inside of the Bartlett's home. When you walked through the Bartlett's home, there were things consistent with someone breaking in from the outside in, right?
Can you tell me what you mean by that?
There were things that you noticed that were consistent with someone breaking into the house.
I'm not sure specifically what you're referring to.
Well, let's break that down. Your Honor, permission to utilize a demonstrative to help aid the jury's understanding of the witness's testimony?
Go ahead.
I'm creating a T-chart with Conan's observations on the left and break-in on the right. You mentioned you're not sure what I'm talking about, but I'm talking about the things. I'm asking whether you noticed things that were consistent with the break-in. So let's break that down. When you walked through the Bartlett's home, you noticed a broken window on the first floor, correct?
Yes, ma'am.
We can agree that broken window, that's consistent with the break-in.
It can be.
You noticed broken glass inside the home.
Yes, ma'am.
The fact that you saw broken glass inside the home, that's consistent with a break-in, correct?
It's consistent with a broken window.
And it also could be consistent with a break-in.
Yes, ma'am, could be consistent.
Especially because that glass, it didn't break towards the patio. Isn't that right?
No, ma'am, it was broken inside of the home, towards the inside.
You also noticed a wide open back patio door.
I did notice, I observed that, yes.
The fact that the door was wide open, that could be consistent with the break-in.
It could be consistent with the break-in, yes.
You also investigated the Bartlett's bedroom, right?
Yes, I did.
In fact, you believed that the state of the bedroom was consistent with the break-in.
Yes, I thought some of the evidence we found there was consistent.
Inside the bedroom, you learned that there was missing watches and missing cash, correct?
That's what the defendant informed me.
The fact that there was missing watches and missing cash, that's consistent with the break-in, correct?
I'm not sure if it's a fact because I didn't take an inventory before, so I don't know if anything was truly missing.
But we can agree that the fact that there was some jewelry missing and missing cash, that could be consistent with a break-in.
I was informed that there were watches and cash missing. I hadn't seen any prior to when I arrived, so that was Mrs. Bartlett's statement.
Bringing you back to my question, you're a detective of many, many years, right?
Yes, ma'am.
So you could agree that missing objects in a room, that could be consistent with a break-in, right?
Yes, ma'am.
Your Honor, permission to preserve this demonstrative and label it as Defense Exhibit A?
Any objection?
Not to preserving it for summation, Your Honor, no.
Okay, granted.
Thank you. I want to now talk about what else you learned about the intruder from Mrs. Bartlett herself. Mrs. Bartlett informed you that she saw the intruder that evening, right?
Yes, ma'am.
She told you that he was 6'3" or 6'2".
That's what Mrs. Bartlett informed me.
She told you he had an accent.
That's what Mrs. Bartlett informed me, yes.
Mrs. Bartlett informed you that he wore a ski mask
Yes,
and that he wore gloves.
yes, ma'am.
In fact, Mrs. Bartlett told you that she saw the intruder shoot her husband, correct?
Yes, ma'am. That's what the defendant informed me.
I want to now talk about what other conclusions you made about Mrs. Bartlett. You reviewed Mr. Bartlett's will and testament, right?
Yes, ma'am.
I'm publishing what's been pre-admitted as Exhibit 7. This is Mr. Bartlett's will and testament.
Yes, ma'am.
It says who gets what in the event that Mr. Bartlett dies.
Yes, ma'am. That's correct.
Mrs. Bartlett's signature is nowhere on this will, correct?
That's correct, ma'am.
You never asked Mrs. Bartlett if she read the contents of the will. Isn't that right?
No, ma'am. But I did discuss the will and prenup with her when I arrived.
Bringing you back to my question, you didn't ask her about the contents, in other words, what this will said, right?
No, ma'am.
No further questions.
Redirect?
Yes, Your Honor. May I proceed?
You may.
Detective, I want to start by talking about the observations that you made on scene. Permission to screen share opposing counsel's exhibit, Your Honor.
Yes, go ahead.
Detective, opposing counsel asked you about some observations you made of the Bartlett's home when you arrived on scene. I want to walk through those now together. Did you find that it was possible for the defendant to break a window and open the back patio door in her home that night herself?
Yes, ma'am.
And how did you conclude that?
Well, the time of death of Mr. Bartlett was between 12 and 12:30 a.m. and we didn't arrive onto the scene until 2:50, so there was time for her to break a window.
All right. What about the state of her bedroom, the missing watches and cash? Did you find that she had time to mess up her bedroom?
Yes, ma'am. She had maybe 2.5 hours between when Mr. Bartlett died and when we arrived on the scene. She wasn't being observed by anybody in the home, so she was able to, or she would have been able to hide any necessary valuables in order to orchestrate a scene.
And Detective, you mentioned before that you weren't able to take inventory, obviously, of the Bartlett's home before this crime occurred. So did you have any way to verify the fact that the watches and cash were actually missing?
No, ma'am.
Thank you, Detective. I just want to briefly talk about the Bartlett's will, the victim's will in this case. Did you at any point confront the defendant with that will?
Yes, ma'am.
And what was her response? Did she deny having ever seen it or known about it?
No, ma'am. She did not respond in that way. She discussed that there had been a possibility of divorce in the week prior to Mr. Bartlett's death.
And that's all she said. She didn't mention the fact that she had never seen that will before.
No, ma'am.
Thank you, Detective. At this point, Your Honor, I have no further questions, and pending any recross, I just ask that the witness be able to step down.
All right, recross?
Yes, Your Honor. I want to talk about something you just testified about on direct. It's true that you did find things consistent with someone breaking in from the outside in, right?
By things consistent, you mean the broken window?
I mean, a lot of things, but bringing you back to my question, you found things consistent with someone breaking in from the outside in, right?
I'm sorry, ma'am. I'm just trying to be specific. I found certain pieces of evidence which could be consistent with a break-in.
Let's break that down then. You noticed a broken window.
Yes, ma'am.
That could be consistent.
Yes, ma'am.
Another example is the state of Mrs. Bartlett's bedroom.
Objection, Your Honor, to asked and answered. May I be heard?
Response? Ms. Podolsky, do you have any response to the objection? Did you hear the objection?
Yes, Your Honor. My apologies. This is within the scope of redirect examination, and this witness is not answering my question as to whether there are things consistent. Therefore, it is necessary to break it down for this witness's understanding.
You've already been over this. You've already covered this. I'm going to sustain the objection. Do you have anything new, Ms. Podolsky?
No, Your Honor.
All right. Okay, thank you, Deputy Commissioner Conanan. You may step down. Ms. Podolsky, are you ready to call your witness?
Yes, Your Honor. At this time, we call Sam McGary to the stand. Good evening, Mr. McGary. I want to start by talking about your background. What do you do for a living?
I own a firm called McGary Consulting.
What kind of work do you do for your firm?
So I test and retest evidence that was originally tested and collected by state and federal forensic technicians. This includes things like electrostatic fingerprinting.
How long have you owned your firm?
Since 2015.
Where did you go to school?
Well, I received a bachelor's degree in chemistry and biology from UC Irvine, and then I also got my master's in forensic science from UC Irvine.
What kind of work did you do after graduation?
I worked for the San Diego Police Department in their CSI unit for about 6 years.
What kind of work did you do for the San Diego Police Department?
I investigated hundreds of cases, and on some of those cases, I testified 16 times in court.
Did you work anywhere after your time with the San Diego Police Department?
Yes, I did. I worked at the Innocence Project as a forensic expert, where I also tested and retested forensic evidence.
Do you have any other professional experience you have not yet discussed?
No, I don't.
I want to now talk about your other qualifications. What, if any, memberships do you hold?
I'm a member of the National Criminologists Association, as well as the American Association of Forensic Examiners.
Have you ever testified before in connection to your work in forensic science?
Yes, I have.
How many times?
When I worked for the CSI unit, I testified 16 times in court, and then I testified 72 times when I was a part of the Innocence Project.
What, if anything, Your Honor, at this time, I move to qualify Sam McGary as an expert in fingerprinting and forensic science. Sorry, Your Honor, I believe you're muted.
Thank you. Ms. Branham, any objection?
I don't have an objection to him being qualified in this case, Your Honor, but I do think we're missing some foundation just about the facts and data he relied on in this case before that tender can be made. I'm not sure if I missed it. I don't object overall, but I would object to lack of foundation at this time.
I think that the foundation for the facts and data in this particular case is probably forthcoming. Let's go ahead and admit him as an expert. And Ms. Podolsky, you may continue.
Yeah, sure.
Thank you, Your Honor. I want to direct your attention to the reason you are testifying in court today. How did you get involved in this case?
I was retained by your office to evaluate the government's newly discovered fingerprint evidence on the discharged shell casing.
What, if anything, did you review in preparation for today's case?
I reviewed the shell casing that's seen in Exhibit 10, the case record, as well as the FBI forensic report. I also spoke briefly to Dr. Emily Hayes of the FBI. I also got some background and context from the case from Elizabeth's attorney, and I also then conducted independent testing of the shell casing in Exhibit 10.
What are your opinions?
I concluded within a reasonable degree of scientific certainty that neither a 20 or an 8-point match is sufficient, unlike what the examiner's report states.
I want to break that down with you. Let's start with the shell casing itself. Your Honor, I'm presenting to the jury what's been pre-marked as Exhibit 10. What is presented on the screen?
This is the discharge shell casing that the detective found beneath the nightstand of Mr. Bartlett's bedroom 26 years ago.
What is the relationship between a shell casing like this one and a gun?
When a gun is fired, the shell casing, which is a container that actually holds bullets, is ejected from the gun.
Was a gun recovered in this case?
No, the gun was never recovered.
Did there come a time where the government investigated the shell casing when it was first found in 1998?
Yes.
In 1998, did you find any identifiable fingerprint on that shell casing?
No, the government did not find any identifiable prints. No prints were found until 2022, about 24 years later, when Dr. Hayes detected a print through the use of electrostatic fingerprinting.
I want to talk about Emily Hayes' findings as indicated in her examiner's report. Before we do, what is electrostatic fingerprinting generally?
Well, electrostatic fingerprinting was first used in Europe less than 10 years ago. It's when a charge is conducted through metal and then you rotate that metal in fine powder. Doing this can reveal fingerprints.
What were Emily Hayes' findings as indicated in her examiner's report?
Dr. Hayes concluded that there was a 20-point match to Ms. Bartlett's right index finger on the shell casing in Exhibit 10.
Did that examiner's report indicate or elaborate on the significance of a 20-point match?
No, the one-page report says nothing regarding the significance or the meaning behind a 20-point match, either in the field of traditional fingerprint analysis or electrostatic fingerprinting.
Shifting gears to your findings, what does a 20-point match indicate to you?
It's not a sufficient match.
Did there come a time where you applied electrostatic fingerprinting in this case?
Yes.
What did you find?
I concluded that there was only an 8-point match. This means that of all of the loops, whorls, and arches that make up a fingerprint, there are only 8 that were common between the partial print on the shell casing and Ms. Bartlett's finger.
What does an 8-point match indicate?
It's also not a sufficient match.
Did there come a time where you applied another testing in this case in relation to the print found on the shell casing?
Yes, in addition to the electrostatic fingerprinting, I conducted a reliable Landingham computer technology analysis to compare the partial print on the shell casing in Exhibit 10 to Elizabeth Bartlett's finger.
What did that test find?
The computer scan found only an 83% probability that the partial print on the shell casing actually belonged to Elizabeth's right index finger.
Does your testing tell us when the print was left on the shell casing?
No, the partial print could have been created years before the discharge, after the discharge, or any time in between.
Does your testing tell us who pulled the trigger on the gun that ejected that casing?
No, it does not.
No further questions.
Cross-examination?
Yes, Your Honor, I'm just going to reposition if that's okay.
Yes.
May I proceed, Your Honor?
You may.
Mr. McGary, I want to start by talking about electrostatic fingerprinting. This method has 2 steps, right?
Yes, that's correct.
The first step is running electricity through metal to see if there's a usable print.
That's right.
You know the FBI performed that first step in the analysis in this case.
Yes, they did.
So did you.
That's correct.
The FBI found a usable print,
They did.
and so did you.
That's correct.
The second part of this analysis is a visual comparison, right?
That's correct, ma'am.
You look at the identified print and you compare it with an individual's.
Yes, that's also correct.
And to do that, you're looking for points of similarity, right?
Yes, ma'am.
You know that the FBI made a determination about points of similarity.
Yes, they did.
Dr. Hayes determined that there were 20 points of similarity between the print on that bullet shell casing and the defendant, right?
Yes, ma'am. That was her determination.
Now, I want to be really clear for the members of this jury. You don't disagree with Dr. Hayes' methods.
That's correct.
You don't disagree with the testing.
It's correct.
You have no qualms whatsoever with how she performed her analysis in this case.
That's correct, ma'am.
Still came to a different conclusion.
Yes, ma'am.
You only found that there were 8 points of similarity between that identified print and the defendant.
That is correct.
Now, I want to be clear, there's a threshold for how many matches or how many points of similarity you need to declare a match of 2 fingerprints, right?
Yes,
Some jurisdictions require 12 points,
that's right.
no more than that.
That's correct.
And some jurisdictions require 6.
That is correct.
But I want to be clear, you don't believe that either conclusion in this case, yours or the FBI's, is enough to determine a match between that lifted print and the defendant.
Yes, that's my opinion.
You don't think 8 points is enough,
That's correct.
and you don't think 20 points is enough.
That is correct.
Mr. McGary, you'd agree with me, your conclusion is a 12-point difference between the FBI's in this case.
That's right.
And you didn't bring any visuals or anything to show us to account for those 12 points of difference, did you?
No, ma'am.
We're just supposed to take your word for that today.
Yes,
Well, I want to talk more about that. You're being paid by the defense in this case, right?
I am. It's standard.
You were paid $50,000 up front
Yes, ma'am. That's our standard rate.
and $20,000 for your in-court testimony.
That's correct, ma'am. That's our standard rate.
Now, Mr. McGary, you didn't have to travel to be here today, did you?
Correct.
You didn't have to book a hotel room to testify.
Correct.
And if my math is right, you've been on the witness stand on this Zoom call for less than 20 minutes now.
That's correct, ma'am.
So altogether, that's a grand total of $70,000 you've been paid by the defense.
Yes, ma'am. That's correct.
I want to talk about the second test you ran in this case, the computer scan you mentioned earlier. You ran the identified print in this case through a computer system.
I did. Yes, ma'am.
In your own words, that method is highly reliable, right?
Yes.
And that computer system also matched that identified print to the defendant.
At an 83% probability. Yes, ma'am.
That's right, an 83% probability of a match to the defendant.
That's correct.
You used other fingerprints and tested those up against the identified print in this case.
I did.
Other prints from people in and around that home,
That's correct.
and those all came back as a 0%.
That is correct.
The only person that test linked that identified print to is the defendant's, right?
That's correct.
Thank you, Mr. McGary. Your Honor, I have nothing further at this time.
Thank you. Redirect.
Yes, Your Honor. You were asked about a 20-point match and an 8-point match and the differences in between by opposing counsel. What does an 8-point match indicate to you?
In my expert opinion, that's an insufficient match.
What does a 20-point match indicate to you?
Similarly, in my expert opinion, that is an insufficient match.
No further questions. May the witness step down?
Any recross, Ms. Brown?
No, Your Honor.
All right, the witness may be excused. Thank you, Mr. McGarry.
Thank you, Your Honor. And at this time, the defense rests its case.
All right, give me just a moment, please. All right, any motions now that the defense has rested?
None from the government, Your Honor.
None from the defense.
All right, Ms. Branham, are you ready for your closing?
Yes, Your Honor, I'm just going to reposition if that's okay.
Yes,
And may I reserve any remaining time I might have for a brief rebuttal argument?
yes.
May it please the court. Since 1998, the Bartlett family hasn't experienced a New Year's Eve the same. They don't smile while watching firework displays. They don't huddle around the TV together, excitedly counting down the seconds until midnight. Now, the loud bang of fireworks is a reminder of the brutal death Martin Bartlett suffered. Every second that's passed since 1998 is a reminder that his death has gone unanswered. Until today. Until right now. Because today, 25 years after Martin Bartlett's death, we've charged the defendant with first-degree murder. And members of the jury, I told you at the beginning of this case that as the government, I had a job to do today. A job to prove beyond a reasonable doubt that it was the defendant who intentionally killed Martin Bartlett on January 1st of 1998. But members of the jury, I'm not the only one that's had a job here today. The law says you have one too. The law says that as a juror in this case, it's your job to act as the fact finders, to look past stories, look past speculation, and focus on the picture the evidence has painted, to focus on the timeline. Because the timeline doesn't forget. It doesn't have any reason to lie. It has no stake in this game. That's what I want to do right now together, is take a look at the picture the evidence is painted, put our evidence on this timeline. And I want to see the evidence that it's painted for us today. Starting with Christmas Day of 1997. You heard testimony today that on Christmas Day of 97, the Bartletts had an argument. That the victims told the defendant he wanted a divorce, and that was a problem. Because you saw this prenup agreement they had signed just a year before. Detective Conanan took the witness stand today. She told you that the defendant admitted not only to knowing about this will, but to believing, or this prenup, excuse me, but to believing that it was enforceable. To believing that in the event of her divorce, she would walk away from her marriage with absolutely none of her husband's assets. But members of the jury, where there's a will, there's a way, and that's exactly what the victim had in this case. A will that divided all of his assets. It didn't even divide them, it just gave them all to the defendant, all $71 million of his estate. The defense has said, maybe the defendant didn't know about this will. Let's think about what she did know. She knew she was a 28-year-old married to a 67-year-old millionaire, living a pretty cushy life, full of expensive gloves, expensive jewelry, and an expensive mansion. That entire life had just been threatened by the victim 7 days before he was shot and killed. Which brings us to the next part of our timeline. The day of the murder, January 1st of 98. You heard today that an autopsy was performed back in 98 that placed the victim's time of death between midnight and 12:30 a.m. on New Year's Day. While the rest of the world was counting down the seconds to the ball drop, the defendant was also counting down for the perfect opportunity to steal her husband's gun, shoot and kill him, and cover up that crime. Because you also heard today that law enforcement wasn't called to the scene until over 2 hours later at 2:30 in the morning. Defense tried to tell us on cross-examination today that, oh, maybe those observations Detective Conanan had on scene were indicative of a burglary. But members of the jury, we know from our timeline that the defendant had over 2 hours alone with that scene. She had 2 hours to change out of her clothes, to shower, to ditch those clothes, the clothes that had her husband's blood all over them, gunshot residue. Because even if we take the defendant at her word, she would have had those things on her if she really was in the bed with her husband that night. But we learned law enforcement didn't find those on her clothing at all. You learn that she had time to ditch expensive jewelry so she could say it had been stolen, $50,000 worth, and a pair of size small women's gloves that she admitted were her size, that were found within 100 yards of the Bartlett home, that are the only article of clothing in this case ever recovered with gunshot residue on them, as well as the victim's blood. These gloves don't match up with the defendant's talk on January 1st about the size of the alleged shooter. Members of the jury, that isn't the only physical evidence, though, that's important in this case. Because you also heard about this bullet shell casing. You heard that it was discovered on January 1st of 98, and it's important for 2 separate reasons. First, because law enforcement, you heard on scene that law enforcement found a box of bullets that matched this bullet shell casing. A box of bullets that was 49 out of 50 bullets full. It was missing 1. What else did we hear was missing from the victim's home on January 1st? The gun, registered in his name. That gun wasn't recovered in the victim's bedroom. It wasn't recovered in his home at all. That's what we heard from law enforcement today. It was never found in this case. Now, the defense paid an expert to get up on the stand today and contest the fact that the fingerprint lifted from the shell casing belonged to the defendant. Despite all Mr. McGary was paid in today's case, we had a lot we agreed on. We agreed, number 1, that there was an identifiable and usable print lifted from this casing. And number 2, that even at the defense's estimate, it was an 83% match to the defendant. I want to be very clear about something. That bullet shell casing may be what brought us into court today all these years after this murder took place, but it's not why we're here. We're not here because of any singular piece of evidence. We're here because of the story the evidence tells in its entirety. We're here because of this timeline, because the timeline doesn't lie. But we know who did. We know the defendant lied when she said a burglar snuck into her home on January 1st and killed her husband. Members of the jury, how many burglars have you ever heard of that steal jewelry from a home, $50,000 worth, just to trash it 2 doors down in the same neighborhood? How many burglars do you know that break into somebody's home expecting to armed rob it and just hope and pray that the victim has a gun they can use to commit that crime? That's what we know happened here. We know the victim's gun was used because it was never recovered. The absence of that gun is as much of a smoking gun as anything else. Members of the jury, the timeline doesn't lie. The timeline doesn't tell stories. It doesn't elaborate. It doesn't forget. But we know who does lie. A wife who stood to gain $71 million from her husband's death. The defendant in this case had 71 million reasons to kill Martin Bartlett on January 1st of 1998. And because of that, because of the picture the evidence has painted, I ask that you do the only thing that justice and the law demands. Find her guilty of first-degree murder. Thank you.
Ms. Podolsky, you ready for your closing?
Yes, Your Honor.
You may proceed.
Elizabeth Bartlett didn't do it. The government has not proven she's guilty because of their immediate assumptions that led to insufficient proof and an inaccurate story. At the beginning of this trial, I told you that we bear no burden in today's case. The government alone had the burden to prove that Elizabeth Bartlett intentionally killed Martin Bartlett beyond a reasonable doubt. I want to remind you that Elizabeth Bartlett remains innocent until you are left firmly convinced of her guilt. The government has failed to meet their burden because of their immediate assumptions, insufficient proof, and inaccurate story. Let's start with the government's immediate assumptions. When Detective Conanan arrived at the Bartlett's 8,000 square foot mansion 26 years ago, he didn't know who murdered Mr. Bartlett because he wasn't there. So we had to find out. He was met at the door by Mrs. Bartlett, the 28-year-old woman, as you can see in Exhibit 2. Mrs. Bartlett took him upstairs to find her much older husband, as you can see in Exhibit 1. In that moment, you know what the detective thought. An 8,000 square foot mansion, a calm young woman, and a dead, much older, wealthy man. It had to be her. Members of the jury, that was the detective's immediate assumption, that it had to be her. From that moment on, his entire investigation surrounded Mrs. Bartlett and Mrs. Bartlett alone. You heard today how Detective Conanan was presented with an alternative story of how somebody broke into the Bartlett's home that night. I'm showing you the demonstrative that we created and labeled as Defense Exhibit A. You know Detective Conanan noticed sign after sign of an intruder. A broken window, broken glass inside the home, a wide open back patio door, a bedroom that was consistent with the break-in, missing watches, missing cash. These are things that the government's lead detective admitted to noticing, but not things that played a role in his investigation. Even after Mrs. Bartlett, the one and only person who did see the intruder that night, described to the detective what the intruder looked like, what the intruder sounded like, the detective still did nothing because he was focused on Mrs. Bartlett. I want you to remember that the government has the burden today to prove to you that it could have only been Mrs. Bartlett who killed her husband. But because the government's lead detective had pre-decided who he thought it was, you're presented with two different stories. And because the government has not proven to you beyond a reasonable doubt that the other story is not true and not possible, they have not met their burden today. This brings me to my second point. The government's insufficient proof. How else did the government try and prove Mrs. Bartlett's guilt? They gave you an examiner's report and asked you to rely on it. A one-page piece of paper that tells you that 24 years later, a 20-point match was detected between a partial print on the shell casing and Mrs. Bartlett's finger. But that examiner's report doesn't even tell you what a 20-point match means. It does not elaborate on the significance of it or why and how you should trust it. Now, even though it's not our burden, we still brought you an expert in fingerprinting and forensic science. You heard all about Mr. McGary's credentials, his education, his experience working with crime scene investigations, and his expertise. So think about what Mr. McGary told you. Mr. McGary explained to you how this shell casing, as shown in Exhibit 10, had a partial print. And that partial print only had an 8-point match to Mrs. Bartlett's finger, which you learned is an insufficient match. We still don't know when the print was left on the shell casing, and it doesn't tell us who pulled the trigger on the gun. Speaking of the gun, members of the jury, 26 years later, we don't have the gun, the murder weapon. The fact that we still don't have a murder weapon is in and of itself a reason to doubt the government's case. But the government still wants you to believe that they conducted an A+ investigation. You heard from Mr. McGary that it's actually only an 83%. And that's a B- at best. That is not proof beyond a reasonable doubt. That is insufficient proof, and you should completely disregard it. This brings me to my third point. The government's inaccurate story. The government spent a lot of their time today telling you a story about Mrs. Bartlett's motive to kill her husband, and a story about how the timeline doesn't lie. Well, let's talk about these stories for a moment. The government wants you to believe that, no, actually, they need you to believe that the 28-year-old woman who had her whole life to live was so desperate for her husband's money that she killed him. But members of the jury, you know that makes no sense. If all she wanted was her husband's money, she could have easily kept him alive and happy and getting whatever she wanted. This story especially doesn't make any sense because Mrs. Bartlett didn't know she would get anything if her husband died. You now know that the government story only makes sense if she knew she would get $71 million if he died. None of the evidence today has shown this. You saw Mr. Bartlett's will and testament yourself. Mrs. Bartlett's signature is nowhere on this will, and no one even bothered to ask her if she read the contents of this will. So, why would Mrs. Bartlett kill her husband? Members of the jury, it's simple. It's that she didn't kill him. It's that someone else did this, and that someone else was the intruder. But because the government immediately assumed Mrs. Bartlett was to blame, all you're left with here today is insufficient proof and an inaccurate story. As you remember that, you will see that the government has failed to meet their burden beyond a reasonable doubt. Now, in a moment, when I sit down, the government is going to come before you and try to rebut everything that I just said. So while I won't have the last word, you can have the last two. Not guilty. Thank you.
Thank you, Ms. Branham.
Yes, Your Honor. May it please the court. Members of the jury, I want to start where opposing counsel just left off. Let's talk a bit about the victim's will. You'll get to take it back in the jury deliberation with you in just a few moments. It's been entered into evidence. I want you to pay close attention to the second paragraph of that will. You're going to see that the defendant in this case was named not as just a beneficiary of the victim's assets, but as the executor of that will. It was not only her right to everything it was going to give her, but her responsibility to divide up all those assets. That's how we know she knew about it. But let's assume for a moment that she didn't. She was living a really lavish life with the defendant, a 67-year-old millionaire. You heard about their house was a mansion. She had $50,000 worth of jewelry. When her husband threatened her with a divorce just 7 days before his death, he threatened that entire lifestyle. Of course, there's motive here. The defendant may not have admitted to knowing about that will before his death. I certainly don't blame her for that. But that doesn't mean she didn't know about it. That's an issue of weight that you get to decide when you're looking at that will. So the defense has said there are two competing stories in this case, the timeline and the defendant's story about a burglary. Let's talk about why that story about a burglary doesn't make sense with the evidence. You heard that $50,000 worth of jewelry was found in a trash can 2 doors down. You heard that the one piece of clothing that had gunshot residue and the victim's blood on it were a pair of women's size gloves found 100 yards from the defendant's home, tossed in the bushes. And the absence of the victim's gun is as much evidence as if we had it. Because if this was an armed burglary by somebody coming into the home to rob Mr. Bartlett, why did they use his gun? How would they have known that he had one? Did they just expect him to? Did they hope? Did they pray for that? Why was it not in his home, locked in his safe, if this wasn't an inside job? The defense is right about one thing. One person killed Martin Bartlett for his money that night. It just wasn't a burglar. There's one person who admitted to being in the room with him when he was shot and killed. One person who stood to gain $71 million from that death. One person whose story didn't add up with any piece of physical or forensic evidence. That person is the defendant. The timeline doesn't lie, but the defendant did. Find her guilty. Thank you.
All right, thank you very much. Ms. Goodman and Mr. Newman, you can let me know when you've submitted your ballot.
Mine was submitted.
Mine has been submitted.
All right, and mine as well. Thank you all very much. That was really impressive and really enjoyable. We have time now to give you some feedback. Ms. Goodman, would you like to offer some feedback?
Yeah, congratulations, both of you. I think you both did really well. In terms of things I think you should watch out for, it seems like maybe you were both working a little bit from a script for your examinations. And when your witness is being difficult, I would encourage you to not get super attached to your script, be in a position to pivot or reframe it. But overall, I think you both did really well. I think you told your story well, and I think both of your closing arguments were really excellently done. So congratulations.
Thank you so much.
Thank you.
Mr. Newman, would you like to offer some feedback?
He wrote to us that he had to step out, I believe.
Okay. All right. All right, well, I'll share a few things. I mean, no matter who wins here, you're both obviously very, very skillful. It's very impressive in terms of where you are, you know, still being in law school and being able to mock litigate at this level. I hope you're both planning on actually going into litigation. I'm a litigation attorney at the United States Department of Labor. I've been there for 20 years. I litigate OSHA cases. So some is administrative law judge trials, and some are in federal district court. And I do a lot of mock trial judging and feedback. One of the pieces of feedback that I often give, even when the students are, you know, really well prepared and skillful, and there's really not much to critique on what you did do, there's one sort of trick or tool that I find is underused, and just, you know, for future purposes. The lead-in questions to the next line of questioning, I mean, you both did that in a basic, effective way. I know you know that you have to sort of tell the jury we're now shifting gears to a new topic, but every time you do that, you also do potentially have an opportunity for argument. And you got to really walk the line carefully. But I think this is underused. So just as an example, Ms. Branham, on your direct, there was an area where you covered what were essentially inconsistencies. And the lead-in could have been, let's talk about some of the inconsistencies between X and Y. You know, I mean, is that going to, in the end, make a difference in the outcome of the case? Probably not, but as an art form, litigation as an art form, that's something to keep in mind. Every one of those is potentially an opportunity. Ms. Podolsky, I think you're one of the ways in which you're in a challenging position is this age difference and the wealth. And one of your arguments among many is that the detective made an assumption when she first arrived based on these sort of classic, you know, this age difference and the wealth and all that. And at the same time, you're hoping the jury doesn't make that assumption. I felt that this is very subjective, and I can imagine, you know, other people feeling differently. When you put up the two photos, you didn't really hit home that the point is everyone might have a certain prejudgment, including the detective. And it could have been that I just missed it, you know. But at that moment, I was thinking, when you show those two pictures, you know, whether we should be, you know, judging or not, that's everyone's instinct, and that doesn't help you. That was one thought. I do think another comment for both of you, but I think Ms. Podolsky, you fell into this trap a little bit more. If you have a really good idea of what's coming on cross, and you know you're going to want some, you know, redirect opportunity, if you happen to get something new and juicy from the cross, great. But if not, try to plan ahead for just a slightly different spin on the same thing. Again, it's sort of the art form thing. You might be going essentially back over the same material, but if you can spin it in a way, you know, you asked questions on direct that were asking for positive answers. On redirect, it's maybe you can, you know, get them to agree to negative, something along those lines, just so it doesn't seem like the same material.
Yeah.
One other question for Ms. Branham. Could you have objected that, I mean, the experts can give their opinion, obviously that's the very definition of an expert, but they're still not supposed to invade the province of the jury and make legal, give, you know, legal opinions. So whether a 20-point match or an 8-point match is enough to convict someone, in my opinion, would be sort of an ultimate legal conclusion that we shouldn't really be hearing from the expert on. The expert should have the leeway to say something along the lines of, in my industry among experts, we feel that a 20-point match, blah, blah, blah. And he kept saying 20 isn't sufficient, 8 isn't sufficient. I just wonder whether you could have objected that that's, you know, offering a legal conclusion. Did you think about that?
Yeah, absolutely. I did think about that for sure. I must have misunderstood that testimony. I understood it to mean that 20 points of similarity wasn't enough to say the fingerprints matched, which I felt was within his, you know,
Yeah,
field of expertise. I wasn't sure if he was saying not enough to convict. I
right.
must have missed that part if it was said.
Yeah. Yeah, it's very nuanced, the difference between those two things.
Yeah.
I guess you could have objected, even knowing you might lose the objection,
Yeah, absolutely.
but making the point for the jury.
Yes. Yeah, absolutely.
He's not, you know, he can't
Yeah.
tell you how to decide this.
Yes. That's super
Yeah.
helpful.
Yeah, that's the feedback I have. Did either of you have any questions in terms of, was this effective? Was this not effective? If not, it's fine. Just wanted to give you a chance.
Not right now. There's definitely things I wish I did differently, but that's just how you
Yeah,
always
always.
feel after these things.
Yeah.
There always is. There always is.
Yeah.
No,
But
that was
thank you so,
good.
sorry, I was just gonna say thank you so much for your time.
Oh, sure. It's
Yeah.
a lot of fun. And you guys were, this was very, very high quality, so it was really enjoyable.
Thank you.
Thank you so
Wish
much.
you both the very best.
Thank you.
All right.
And Abby, you're amazing.
Yeah, so are you. This was such a fun round, super hard. So
Yeah.
yeah,
Thank you.
yeah. Thank you so much. I'll see you